you very much, Rashmi, for such a warm welcome. I would first like to extend my undiluted gratitude towards Ms. Mehak Rathi, my friend, my colleague, that she has encouraged me and suggested me to speak on a topic which is quite a lot talked about. And secondly, Sanidhya and the whole organizing team. Thank you very much for being here. And I would like to start with the background of this case. I'll try to summarize it in a brief manner as I can. So I'll just show you the history, like what gave encouragement and what gave a start to this case is the very essence of our suit. I'll just read out the basic dates and events which are very important in this particular case, and it's very important for all of us to understand what the crux of the issue is. I'll just start with I'll go brief in brief time in the history as well. I hope I'm audible to everyone because there is no response from the other side, so it's
Yes, sir,
very
you are
difficult
totally
for me to
audible.
You are
understand
audible, sir.
if I'm audible or not. So back in history, if we see that in 1618, in fact, if we see the history in 1618, Raja Veer Singh Dev Bundela, this one king was there of Orcha. Orcha is a district in Madhya Pradesh, which is very much closely related to Mathura. It shares its boundary with Mathura and Agra as well. So Raja Veer Singh Dev Bundela of Orcha built and renovated a temple at the cost of rupees 33 lakhs at that point of time, at the birthplace, that's the Janmsthan of Lord Shri Krishna, at Katra Keshav Dev, Mathura. So from there we have the documented evidences. Now on 31st of July, 1658, when the Aurangzeb was the ruler of and Agra and Mathura were a part of his regime, in 1669 to 1670, Aurangzeb got partly demolished Sri Krishna temple at the birth of Lord Krishna, situated at Katra Keshav Dev, and structure was erected, and same was termed as Eidgah Mosque. There's a very famous farman in the book of Aurangzeb that's called Masiri Alamgiri, and we have also quoted it. I'm one of the counsels in the Krishna Janmabhoomi matter, and I'm assisting Sri Hari Shankar Jain sir and Vishnu Shankar Jain sir in that matter. So that it's a matter of fact in history that Aurangzeb ruled the country from 31st July 1658 to 3rd of March 1707 AD, and he, being a staunch follower of Islam, had issued orders for demolition of large number of Hindu religious places and temples, including the temple standing at the birthplace, and temples including the temple of Lord Sri Krishna at Katra Keshav Dev, Mathura, in the year between 1669 to 1670 AD. Now the army of Aurangzeb partly succeeded to demolish Katra Keshav Dev temple, and construction was forcibly raised, showing the might of power, and said construction was named as Eidgah Mosque. There was an order passed by this Aurangzeb, finds a place in the official court bulletin, which was known as Akbarat at that point of time, of January and February of 1617, which has been translated from Persian to English by a preeminent historian, late Jadunath Sarkar. And the same was being produced by us before the trial court as well. The order said that during this month of Ramzan, that's between January to February 1670, the emperor, the reviver of the faith of the prophet, issued orders of the demolition of the Tihura of Keshav Rai in Mathura. In a short time, the destruction of this strong foundation of infidelity was accomplished, and on its site a lofty mosque was built. The idols, large and small, of the temple were brought to Agra and buried under the steps of the mosque of Begum Sahib, in order to continually trodden upon The name of Mathura was changed to Islamabad as well, and that's what is written in Masiri Alamgiri, page number 95 to 96 of that particular book. Then again, a grand, huge, and lofty temple of Lord Sri Krishna at his birthplace at Katra Keshav Dev was existing in 17th century. During 1658 to 1707, during reign of Aurangzeb, one Italian traveler, Nicola Manucci, who worked in Mughal court, described regarding demolition of temple by Aurangzeb in his book as well. The name of his book was Storia the Mogar, or Mughal India during 1653 to 1708. And he records the fact that several important temples, including Sri Krishna Janmabhoomi at Mathura, were demolished by Aurangzeb, but shortly thereafter, Hindus thronged they had thrown those sacrifices, those sacred sites, and started worshipping as they were doing in the past. So these were the evidences that we had, and based on there are many, in fact, but these are the very few of them over which we have placed our reliance and placed our suit before the court, which is pending for the trial. Now, I would like to give you a brief, in fact, a highlight of the case as well, as to what led us to this particular aspect right now. Now, we were in 1669 to 70, somewhere in between, when Aurangzeb partly demolished this temple. And in 1770, Maratha won the Battle of Govardhan and became the ruler of the entire area of Agra and Mathura. Then Marathas restored and renovated the birthplace temple of Lord Sri Krishna at Katra Keshav Dev after removing the so-called structure of mosque. They were declared the land of Agra and Mathura as Nazul land. Nazul land is the government land. So then the land was under the control of the Marathas. Then in 1803, East India Company under Lord Lake conquered the area of Agra and Mathura and defeating Maratha ruler Sindhya army in the year 1803 and became ruler of Agra and Mathura since then. The British government also continued to treat the land of Agra and Mathura as Nazul land and not as temples. In 1815, the British government put for auction sale 13.37 acres land of Katra Keshav Dev through public auction, which was purchased by Raja Patnimal of Banaras. In pursuance of auction sale, Raja Patnimal became the owner in possession of 13.37 acre land of Katra Keshav Dev. It was in the possession of Raja Patnimal of Banaras. Then in 1860, in settlement map, the compound was described as Katra Keshav Dev, from wherein we have taken this name out. It's from the settlement map of 1860. Then 1865 came. 6 decrees were passed during that period of time in favor of Raja Narsingh Das, the descendant of Raja Patnimal, in respect of the property of Katra Keshav Dev. Now in 1903 as well, a survey map was compared. A survey map was compared at the spot, and it was found that the site was clearly numbered as 321, and temple of Gangaji was also there. Subsequently, in 1991, the property of Raja Patnimal came under court of wards, and compound Katra Keshav Dev was administered by the collector of Mathura, since it was a Nazur land. Then in 9th of March 1921, one civil suit was filed by the Muslims claiming the land, and that claim was dismissed, holding that the land in dispute did not belong to mosque, and the plaintiff, who was Muslims at that point of time in that particular suit, the plaintiff was not in possession, and the Hindu defendant was building a temple upon the site of previously existing temple. This is a matter of record. It's everywhere across the documents that we have filed and before the court as well. In 1944, Rai Kishan Das and Rai Anand Das, the legal heirs of Raja Patnimal, executed a sale deed of that particular 13.37 acres of land of Katra Keshav Dev in favor of Mahamana Pandit Madan Mohan Malvi, Goswami Ganesh Dutt, and Bhikan Lalji Atre on a mere consideration of rupees 13,400 only, which was paid by Yugal Kishore Birla. It's a very important fact that that particular 13.37 lands was owned and possessed by such great legends of our country, Pandit Madan Mohan Malviya, Goswami Ganesh Dutt, and Bhikan Lalji Atre. In 1951, Jugal Kishore Birla created a trust which was registered on 9th of March 1951, specifically mentioning that the entire land property measuring 13.37 acres of Katra Keshav Dev will vest in the trust and it will construct a glorious temple. So that was one of the objectives of the trust that was formed by the then legends and greats. Now, in 1953, one civil suit that was filed in 1946, filed on behalf of Masjid Idgah against Pandit Madan Mohan Malviya and others for preemption on the basis of sale deed dated 8th of February 1944 between the descendants of Raja Patnimal and the three great legends that I talked about, and was filed. The suit was dismissed on the basis of compromise, holding that the judgment dated 2nd of December 1935 that inherited the rights of the land to the descendants of Raja Patnimal was correct, and it was passed by then the Honorable High Court, and that would be binding on the parties as well. That's a very important turn of events that happened in 1958, that a society known as Shri Krishna Janmsthan Seva Sangh, I'll repeat, a society known as Shri Krishna Janmsthan Seva Sangh was formed, and after amendment was made in UP in 1977, the word Sangh was replaced with Sansthan. It was barred to use. So one more society was formed in 1958. Now, in 1959, Muslims filed a civil suit, so and so, against Sri Krishna Janmabhoomi Trust, not on the Sansthan, but on the trust, on the basis of sale deed executed by alleged Trust Masjid Idgah in their favor. And the suit was dismissed, holding that the sale deed was executed without any authority and same was illegal. Then again, in 1964, one more civil suit was filed in the court of Munsif of Mathura, but same was returned to the plaintiff for filing in proper court, and thereafter the suit was filed before the civil court, civil judge of Mathura, under court case number so and so, under the caption Shri Krishna Janmsthan Seva Sangh Mathura, also known as Shri Krishna Janmabhoomi Trust Mathura, registered under Act 21 so and so, along with 15 members of the society. Now, this is a very important point. The suit was verified by Joint Secretary of Seva Sangh, but it was filed in the name of Krishna Janmabhoomi Trust and not in the name of Krishna Janmabhoomi Sansthan. Subsequently, in 1968, a compromise was entered between Sri Krishna Janmabhoomi Seva Sangh Mathura through authorized office bearer and alleged Shahi Masjid Idgah Mathura through representatives on 12th of October 1968. In compromise, the society, without being the owner, now this society, the Sansthan, has entered into a compromise deed with the Shahi Masjid Idgah community. In compromise, the society, without being the owner and having no right or power over the land of Katra Keshav Dev, accepted some demand of the trust Masjid Idgah against the interest of the deity, the devotees, and the objectives that was laid down in that particular trust that was established by Pandit Madan Mohan Malviya and the other legends. And the same compromise deed was registered in the year 1968. Now, the suit that was pending before the learned civil judge was decreed upon the basis of this compromise deed, under which the area of the Krishna Janmabhoomi Sansthan, where the Lord Sri Krishna, according to the various books of history, have taken birth, has been given to the Muslim Community Trust. And from therein, we term it as a decree obtained by fraud. Then, in subsequently in 2019 and 20, there was some turn of events, and then we came to know that that particular decree, that particular compromise deed, was based on a mere lie. It was the compromise deed was signed by Krishna Janmabhoomi Sansthan or Son, which did not have any particular interest, right, or ownership or title of the property. So this was the whole issue, and then we filed a civil suit before the competent court of Mathura, and then several other suits were also filed. And since there were a lot of suits in Mathura, and there is a provision of under Section 24 of CPC, under which the consolidation of all the suits and transfer of all the suits is possible from the district court to the high court. So we have filed that, and now the matter is pending for adjudication before the London Honorable High Court of Allahabad. So I really hope that till now the aspect of the whole brief history and the aspect of Krishna Janmabhoomi case is quite clear to all of you. And Sanidhya had given me 15 minutes to speak on the introduction and background part. So Sanidhya, if you have any question, any query regarding it,
Yes,
then
sir.
please ask.
Rashi will be taking up the
So,
questions, sir.
yes, sir.
Yes,
Actually, there are some questions from the audience.
right.
And the first one is like, why courts take time in matters which are related to the religious beliefs?
Because courts should take more care about these issues. It should not be decided in a hurry. And till now, I believe that we are moving very fast. There are some other religious matters as well that is going on uh, before the concerned courts. And I believe that the courts should be more patient. It should be more judicious while adjudicating such matters, because it's going to affect the whole of the country's civilization in the coming of the years. So there has to be no stone unturned for the courts to decide. So it's better that it takes time, but yeah, justice delayed is definitely justice denied. So this is a particular case filed by the deity himself, and by and the devotees of the deities. So the devotees of the deities are the ancestors of the people who were at that point of time during the time of we call it slavery, if you not mind. I call it a slavery era of India. So it was for the ancestors actually that we are fighting for. So it's a case pertaining to more than 400, 500 years now. So it will take some time at least, because there are many facts of the history that has to be adjudicated by the court. There are many books of records that has to be taken into consideration before giving any judgment. What happened in the Ayodhya case as well, if you remember.
Yes, sir. So, there is one more question. Like, what are the different cultural and political interests involved in this particular dispute?
Well, that's a very tricky question. I would like to avoid it, but since you have asked it, I, well, there is a political interest. You can say that because, uh, well, if you see the Ram Janmabhoomi case, the building of the construction of the temple was there in the manifesto of the ruling party. Number one. Number two, we are yet to wait for the memento of this particular election of the different parties, and we, as of now, do not know if the government is interested in pursuing this particular adventure or not. So it's very difficult for me to comment upon this aspect. But as a counsel for the plaintiffs in this particular suit, I must tell you that there is no government interference and there is no encouragement from the government to us. It's I think it's the part of the media that is playing a very crucial role in highlighting and changing and improvising the perspective of the mass media. And the question is directly related to the TV channel debates that is coming through. And I believe that as personals from the legal fields, we should be stuck, and we should be more focused upon the legal aspects of this particular case. That a compromise decree was filed, compromise decree was signed, and the parties that signed the compromise deed, was not the competent authority to sign that particular aspect. And hence, the decree was obtained by fraud. And that's the only thing I would like to say.
Right, sir. The third question from the audience is, it's like, can you tell about the process of survey and the importance of conducting survey matters relating to this case?
Yes, we have filed one application under Order 25, Rule 9 and 10 of the CPC for the appointment of a court commissioner who will go there, and after inspection, he will give his report to the Honorable Court. Now, what's the purpose of this court commissioner? Let us understand that we as a plaintiff, we as aggrieved party, have approached the Honorable Trial Court. Now, the trial court, we have presented our evidences, we have presented our arguments, we have presented our submissions. But those submissions, those evidences has to be verified, since it's a very important case. And the judge, the learned judge does not know whether what all we are saying is even true or not. If we are claiming that there is a temple, there are certain idols, there are certain signs and symbols in the premises of that particular temple that belongs to a Hindu community, that reflects that the religious character of the place is not a mosque but a temple, then it is the duty or the apprehension of the court, I guess, that it appoints that it appoints a court commissioner on his behalf, who can go there and testify our submissions, testify our evidences, and present it before the court. So basically, court commissioner is the hand of the court, that we say. So, and we have filed this application, and it is still under challenge before the Honorable High Court. The opposite party has challenged our application, saying that they have moved an application under Order 7, Rule 11. So they are saying that we should adjudicate that particular application first, that is related to the maintainability of the suit. And after that, we can proceed with the appointment of the court commissioner.
All right, sir. The fourth question that has been asked by one of our audience is, what was the impact of Places of Worship Act on this issue and the view of Ram Janmabhoomi case?
Well, the Places of Worship Act clearly exempts the Ram Janmabhoomi dispute. The title of the Ram Janmabhoomi, it's Section 5, if I'm not wrong, of Places of Worship Act, which exempts Ram Janmabhoomi. Now, coming to this particular aspect, it is still under trial, and the trial court is yet to decide this particular aspect of Places of Worship Act. But our submission is very simple. It's that the Places of Worship Act, if I'm not wrong, if I can open it, I can also read it as well. Places of Worship Act, actually, it's very well illustrated in the Ram Janmabhoomi judgment as well. It's very beautifully crafted. So, Section 4 of this particular act, it says, I think you all can Google it. You don't have to be so formal. Now, the second aspect, the second provision of Section 4 says that if on the commencement of this date, any suit, appeal, or other proceeding with respect to conversion of the religious character of any place of worship existing on the 15th day of August 1947 is pending before any court, tribunal, or authority, the same shall abate, and no suit, appeal, or other proceeding with respect to any such matter shall lie on or after such commencement in any court, tribunal, or other authority. Now, provided that if any suit, appeal, or other proceeding instituted or filed on the ground that conversion has taken place in the religious character of any such place after the 15th day of August 1947 is pending on the commencement of this act, such suit, appeal, or other proceeding shall not so abate. Now, this particular compromise deed was signed in the year 1968, which is definitely after the 15th day of August 1947. And since it says that the conversion has taken place in the religious character of any such place after 15th day of August is pending on the commencement of this act, such suit, appeal, or other proceeding shall not so abate. So our basic submission is that we do not fall into that particular criteria of places of worship act. So it does not apply to this case because the conversion took place post 15th of August. I hope I'm
All
clear,
right.
Rashmi. Yeah, the viewers can ask himself or herself. I do not mind.
Okay, sir. Let's just take the next question and I'll ask the viewers
Right.
to feel free to ask the questions. So our next question is how much it is difficult being an advocate, handling cases which are politically and religious so delicate. Like what all challenges you face as an advocate?
Well, first of all, I firmly believe that since law is neutral, since law is neutral, so the lawyer should also be first of all. Now, if we are advocating a particular case, that's a different thing. So this is by the virtue of fate or by the virtue of destiny. We are often entitled, we are often called as the some of the extreme elements of the society. But it's not bad to fight for the truth. It's not bad to fight against the injustice. It's not bad to fight for the ancestors. So it's for the atrocities. If you read well about the history, uh, you'll understand more about the Indian civilization, about what a true freedom, what a true independence is. Now, the independence is not only from the colonial rule, we were also in slavery, even prior to that as well. Now, no disrespect or no comment upon the present community that is living at this moment, but that was the rich cultural heritage of our country as well, and that has to be preserved. That's one of the directive principles of the states as well, the Article 51. So, as an advocate, it's not very difficult to be very honest, but as any other part of the society, it becomes very, very difficult to argue on the facts or to argue on the things that you see in the social media or the media, print media, or these news channel debates. So, this is my humble submission to some humble suggestion to everyone that please stay away from these social media debates. It does not solve any purpose. They have their own purpose of increasing their TRP and increasing their business. So it also affects our cases as well because the judge is also watching the news channel debate, and this is for any of the side. Right.
Right, so. So the next question is, what can be done to prevent similar disputes from arising in future?
There should be no invasions from now. I think the sovereignty of the country is very important, and since we have our own constitution and we have been through a lot, this is not the time to think about more more atrocities and more invasions, but this is for the time for the development, I guess. So in future, I think We should highlight, and we should analyze, like what are the disputes that needs to be resolved. Like past wounds have to be resolved in order to have a balanced society and a harmonious one, in fact. And by having such discussions, I believe that uh, the awareness is there in the masses and should go there.
Right, so very right. So the next question is like, is the government doing right to target mosque to gain majority population attention and manipulating younger generation towards hatred, towards secularism,
Secularism towards not secularism, I think that's the question.
towards secularism?
Now, point number one, in this particular aspect, if you see the memo of the parties of our suit, uh, government of India is not a party, right? And that's why I'm clearing this out, because this is a very uh, basic misunderstanding amongst the people, that government of India is trying to uh, uh, interfere in this particular case, or in any manner is assisting us in this particular case. So I must tell you that government of India is not a party in this particular suit. It was purely a civil dispute between two parties, and those two parties tend to be religious communities as well, that belong to religious communities as well. Now there was a temple, no doubt. It was in the book of history, and uh, there are many evidences that shows that there was a temple. And there, the particular area in which Lord Sri Krishna took his birth, it was also there. But then there is a civil dispute between two parties, and those two parties are fighting over the civil disputes. We are supporting one of the parties in that particular civil dispute. Now there is no government interference in this particular issue. I must say that. So I don't think that government in any manner is trying to uh, encourage the youth towards hatred, is encouraging youth to be not so secular. In fact, I was seeing some of the social media posts when this Ram Mandir was inaugurated, and they were showing some preamble of the constitution who were against this particular judgment. You know, see the preamble, see the preamble, see the preamble. So that particular preamble forms the is the soul of the whole constitution, and that constitution has, by its own mandate, has formulated the bench of the Honorable Supreme Court, and that particular constitutional bench has passed that very judgment of 1,000 pages. So we must respect the judiciary. We must respect the judiciary because it lies in the soul and body of the constitution. So it's not the government that is forcing and encouraging the youth, but our dispute and our submissions, our averments are only there till the courts. There is no one behind us. There's only one court which is in front of us. That's all I want to say about this particular thing.
All right, sir. So our next question from our audience is, after these many years, how can we claim our right on that mosque? Like, kindly share your views on the same.
First of all, it's not the claim on the mosque; it's the claim on the land, right? And there is a discrepancy in the transfer of the titleship of that land. Correct? Till 1968, that particular portion of land, it belonged to this Krishna Janmabhoomi Trust. Correct? Now, Krishna Janmabhoomi Trust, by virtue of some deceit, there is one more society was formed, and without informing the trust and without informing the trustees, they have filed a suit, and they have compromised it through the compromise deed with the other party. The other party has come to the possession of this land, and the true purpose of that trust, the true purpose of the devotees, got eventually lost. Now, at this particular point of time, we are seeing that decree of 1974, which was passed on the basis of the compromise deed or a settlement deed. Now, that particular settlement or a compromise deed is based on fraud. That the transfer of the title and the transfer of possession and ownership was based on a lie. So the records of the particular land records are affected by that. If there is any dispute that has to be resolved, it has to be resolved by proper and just means. And if it comes before the eyes of the law and before the eyes of the lawmakers, it's the duty of the lawmakers, it's the duty of the judiciary, it's the duty of advocates as the assistant and the court and the friend of the court to tell the court that this injustice, this improper uh, uh, adjudication of a particular suit has happened. And now, since it has come before the eyes of the law, it is the responsibility of those lawmakers and law binders and decision makers to do something about it. And we are just trying to help the court, help the just cause. So that's the whole crux. We are not going in the emotional and those aspects, religious aspects of the place.
All right, sir. So our next question is, can the Honorable Court order for demolition of any religious place on the basis of ASI report? If yes, then is it valid under which law?
No, it cannot be possible only on the basis of ASI. There has to be a lot of other things and other factors as well that has to be taken into consideration, and the trial court is well equipped to analyze and to sustain or to reject those evidences as well. So it purely depends upon the court. If you see the Ram Mandir judgment, the whole Ram Mandir judgment was not only based on the report of the ASI. The court's commissioner report in the Ram Mandir was first filed in the back in the year 1950. The court commissioner report was filed in 1950, and then on that particular report, after so many years, a particular ASI team was granted the was given the directions to go and do the analysis of the site. And ASI can only the survey of the ASI can only assist the court. The whole judgment cannot be based on the findings of the ASI. If you see the Ram Mandir judgment, the whole 1045 pages were not only on the ASI, it was also, there are many other aspects as well, such as the right of the deity, whether the idol has any juristical right or not. Because this particular case is also filed by the Sri Krishna, and that was filed by the Ramlala.
Yes, sir. So the next question is, what other factors beyond religious and historical claims contribute to this ongoing dispute?
There are not there is no other thing other than that particular compromise deed that was signed, that was executed, that was presented before the court by the parties who did not have any right over that particular land. So if you do not have a particular right, have a right or ownership of a land, how can you sell it to the other party? I think the media and the common nexus of the people and common understanding of the people is that it solely depends upon the religious aspect. But there is more to it than a religious tint, right? So I don't think there is many other factors that are involved in this particular case. The history, the evidences, the report of the court commissioner, if it comes in future, then it will only assist our claim to that particular property, and nothing more than that.
All right, sir. So the one last question,
Right.
which I would like you to please address. Did any of the community or certain people are unhappy with our actions in reclaiming of our temples through the legal battle?
Yes, there is always a legal recourse to it. First of all, this is a trial case which is going on. This is going on in the before the Honorable High Court. Now, for the further course, if in fact we do not know if there will be a division. There's a single bench who is which is currently hearing this particular issue. So even in fact, even we do not know that if it goes to the division bench first and then it will go to the Honorable Supreme Court or not, or it will directly go as a criminal appeal to the Honorable Supreme Court, or sorry, civil appeal to the Honorable Supreme Court, or a civil revision to the Honorable Supreme Court, or a division bench. So there's if any of the party is unhappy, whether it's us or whether it's the other community, they have a right to appeal. They can go there.
Okay, sir. So there is one last question.
Right.
That Sir, any advice that you would like to give to our audience?
Stay away from the TV news channel debates. I must say that, because in our case, I'm also one of the counsels. I'm also assisting my senior advocate Vishnu Shankar Jain in the Gyan Vapi issue as well. So even the court strictly told everyone in that particular court to please stay away from the news channel debates and the views presented by the spokespersons or the other people of political parties not belonging to the political parties. They are only trying to fuel their own TRPs and nothing else. So stay away from the rumors, stay away from the news channel debates. Read newspapers. That's a more reliable source, or reach out to me anytime if you have any query or any discussion. I'll tell you, because there was one rumor as well that if we appoint a court commissioner, and the court commissioner will go with a JCB and start digging the mosque. No, it's not going to happen. It does not work like that. So that was just a rumor that was aired in the social media, and that particular air, which is not even true, was then sparking some hatred and some heated exchanges between the friends and the families as well. So that's all I can suggest, Rashmi.
Okay. All right, sir. Thank you, sir, for giving us your valuable time. And I would also like to thank Mehak Rathi ma'am. And I hope everyone find this session to be fruitful and knowledgeable. Thank you, everyone.
Thank you, Rashi. Thank you very much for calling me here. I once again thank all the participants for hearing me out so patiently. And thank